Welcome to Application Development and the Law, GDPR, DTSA, etc. I'm Sebastian Holt, Chief Strategy Officer here at PreEmptive Solutions. This session, we'll take a closer look at how the incoming waves of regulations and legislation are impacting development and DevOps organizations in particular. Analysts, pundits, the press tend to focus on IT and operations when looking to assign responsibility and by extension blame when it comes to compliance and governance, and candidly for good reason. But as we'll explore more today, while development may often be overlooked in this context, it is most certainly not exempt. And as legislation and regulations themselves modernize, we can see an increasing focus on development and DevOps. So that's where we're going to spend our time today. Go. So if Willie Sutton were alive today, right, I like to say he wouldn't rob banks, he'd be a hacker, right? For those of you maybe of a younger generation, Willie Sutton is perhaps erroneously, but still well known for answering the question why he robbed banks, and the answer was because that's where the money is, right? So today's criminal is much less likely to have a machine gun or dynamite, and much more likely to have a decompiler or a debugger network sniffer. Why is that? Well, there's a whole new generation, a whole new way of committing old crimes, right? Robbing financial institutions, industrial sabotage, trade secret theft. Obviously, our digital economy has opened up a whole new vast array of ways to be that type of a criminal. But there are also new crimes that really didn't exist in the past. Identity theft, ransomware are two obvious examples. And, progress marches on. There's new ways of committing these new crimes. I'm not going to go into lots of examples, but outsider trading as opposed to insider trading, where St. Jude's was a famous example, or sort of a good example of this, where somebody found a vulnerability inside a medical device, and rather than go to that manufacturer and hope for a bug bounty or something of that sort, they went to a VC and or investment banker, and they shorted the stock, made tons of money, right? So short selling on critical vulnerabilities is a new way of committing a new crime. And against this backdrop, our regulators and our legislators are drafting new rules, new laws, and new regulations. And we're going to focus in just as examples around privacy, the European regulation that comes into full force in May of next year, GDPR, Defend Trade Secrets Act, not ART, DTSA, is one around intellectual property. And we'll look at guidance for sort of a modern industry around intelligent and self-driving cars, smart cars, and self-driving cars. So we'll look at all of these things in the context of how development and DevOps are being specifically identified as stakeholders. Now, one of the regulators and development organizations see the same world in two very different ways. In fact, actually, I wrote a piece, developers are from Mars and lawyers are from Venus at SD Times, but on this topic already. But let's take a more concrete look at how we can categorize or sort of compartmentalize the way these two very different personas approach this issue. And again, with the idea of allowing us to more productively prioritize and focus on the important issues. So if we look at legal and regulatory community, right? So the thing that tops the chart, right, is not the definition of the crime or the regulation. It's the penalty. If you don't have a penalty attached to a law, candidly, it never gets any attention, right? So penalty equals priority. So a great example, sort of maybe a negative example of this in the U.S. was COPPA, the regulations to protect children's privacy. Turns out there hasn't been a whole lot of enforcement around that, and so candidly, while there was a lot of activity around the rules and regs protecting the identity and the targeting of children, that's really, other than Disney and a handful of other very large enterprises, that is not a regulation that has gotten a lot of priority because there's very little prosecution and very low penalties. Then there's the definition and the scope. So who exactly is being governed and what exactly is being measured, right? These are critical distinct things to identify amidst all the words that you might find inside a regulation. And extremely important, what is the standard against which these things will be measured? And two sort of concepts that we'll focus in on today, certainly, is this notion of reasonable and state-of-the-art. Reasonable is really norm-based. So it's important, I think, to think about this not as reasonable, you have to get a 7 out of 10, state-of-the-art, you need to get a 9 out of 10. It's actually more profound than that. Reasonable is norm-based. So if you're in lumber, right, and somebody hacks into your customer database, you know, a court or a regulator is likely to say, well, you know, what do all the other lumber companies do? And have you been doing essentially this, at least the same amount of protection controls as your peers? And if you have, that's sort of reasonable, okay? The fact that, and I'm not picking on lumber, hopefully there are no lumberjacks here on the webinar today, but the idea here is, you know, lumber companies may in fact not be all that sophisticated in protecting PII for the most part. State-of-the-art says, well, no, it doesn't necessarily mean state-of-the-art, like what is MIT, you know, doing in their research lab. State-of-the-art says in commercial enterprise, in our global economy, what is well understood, what is well known, what is a common practice, right? So in state-of-the-art standard, the entire lumber, in my hypothetical, the entire lumber industry would be in jeopardy. There is no more safety in numbers. So as we start looking at how regulations that look to state-of-the-art as a standard, you can no longer use what is a valid, often, practice, which is let me benchmark what I'm doing against my peers. And, you know, in the cliche, I don't need to be the fastest running from the fair, just not the slowest, right? Well, state-of-the-art is very different. If financial institutions, if manufacturing companies all understand what it takes to protect intellectual property and personally identifiable information, well, somebody in that lumber corporation needs to get in touch with those people and figure that out. And this is sort of icing on the cake, notification, which you're seeing increasingly around, certainly around privacy regulations. When something bad happens, there are all sorts of obligations about notification that something has happened. So how quickly do you need to notify? Who do you need to notify? And what are you obligated to tell them? And this is like a whole other way to fail, right? So you might fail by not, say, sufficiently protecting your data and your customers and your employees. You can fail again by not notifying people properly, right? So so that's a regulator, a lawyer, a risk management sort of universe. Well, now development, and this is actually not all that common. I don't see this all that often, but this I think is important. People, when they're thinking about application security or they're thinking about hardening applications to secure data flowing through those applications, they think of hackers, bad actors, as entities they wished didn't exist. They would just go away. And in taking that approach, they de-skill themselves. Development organizations, good ones certainly, are quite expert at identifying and describing personas, personalities that have sort of an archetype, and you build stories around these personas. Now, typically, that effort is designed to attract, retain, engage, delight the personas that you're targeting. But without a doubt, the same skill set needs to be deployed to repel, distract, antagonize, punish bad actors. Right? So you need to really think of these as personas to understand how to effectively manage those risks. Now, prevention, there's a number of controls, some of which we'll talk about, like obfuscation to protect against reverse engineer, or to prevent reverse engineering, I should say. A lot of other sort of optimization things like linking. Optimization often will have, or optimization in general will often have a sort of a side effect of protecting and obfuscating itself. Say preventing the use of tools that hackers like to use, not to actually exploit a vulnerability, but to find a vulnerability. Right? So we'll get to this in a little bit, but what we'll find, just the way lock-picking tools, for example, are kind of controlled. Right? You don't, for some types of people, actually being in possession of lock-picking tools is a crime. Right? Well, hackers love debuggers, they love reverse engineering tools, they love monitoring tools. So being able to build in preventative controls to make it harder for them, those bad actors, to use those tools turns out to be quite effective and quite important. And then you have detective controls. So now you've released your software into the wild, right? You'd like to know if it's been tampered with. Right? Has somebody gone in and directly manipulated your programs, your assemblies? Have they managed to recompile them somehow and redeploy them? Are they running in a compromised environment? So a rooted device would apply, obviously, specifically to an Android device, but jailbroken or a variety of other, scenarios. The idea, and what's important about a rooted device or this type of detective control, is that it doesn't necessarily give an absolute guarantee that there's a bad actor on the stage. Right? The example I like to use is, if you're a financial institution, I don't know, in Silicon Valley, chances are there's some very wealthy people there who just like to use a rooted Android device because they like to fool around. Now, that bank is not going to tell that billionaire they don't want their business. Right? What they're going to do, perhaps, though, is force, triple, validation of credentials, or log every transaction extra carefully, or. So the idea is often there are ambiguous settings or indicators that should trigger a contextual response, but it's not, a scorched earth approach is definitely inappropriate, right? You wouldn't just brick the device, for example, if a billionaire from Silicon Valley had the nerve to log into their account with a rooted device. You'll notice I have debug here twice, right? So I had it as a preventative control, but in fact, attaching a debugger can in some cases be part of the actual hack. So I might attach a debugger to an active session, a thread of an active session in production, to hijack its session ID, or to elevate my privilege so that I can see data that I shouldn't normally be able to see. So a debugger in this scenario, even though it shows up twice, is a very different scenario. And there's a variety of other detective things, right? So you want to detect if something happens. But, as with, say, a smoke detector, if it goes off, if you don't know what to do when the smoke detector goes off, what good is it, right? So in addition to detection, you want a response or a corrective control, right? So maybe you do want to abort the application. Maybe you want to throw randomized exceptions. We'll provide sample code even where we do have this notion of bricking not a device, but an application, right? So somebody attaches a debugger, you detect it in your application, you can actually brick the application so that if they say, oh my goodness, obviously they have a control here, they restart the application now in a clean environment, no debugger, not rooted, whatever. You can make it so the app never runs again. And then they have to come back to you to get a new version of that app. And it doesn't have to be a mobile app. You can do that on any type of app. The point here is that once somebody does something sort of suspicious or untoward or ambiguous, that actual environment is compromised. And so again, you want to take you want a business response. And so a brick is good about that. You can write to your own logs. You can do a custom behavior, right? I was talking to a company last week. It was factory automation company, make devices or equipment for factory automation. If they detect somebody's attached a debugger, to one of their consoles or something, they do not want to unceremoniously shut down that equipment. It could be catastrophic, perhaps. So they won't let you restart it. They have a custom behavior where, I don't know what they do. They do some immediate sort of defensive triggers. But one of the things they do is not shut the device down. Rather, if you do shut it down or whenever you do shut it down, it won't restart. So sort of quiescing it, right? So the idea, again, custom. And then reporting, right? So it's not just the alert that a particular incident has occurred, but you want to be able to collect and aggregate, look for trends that come out of attacks or suspicious activity over time, over space, across different communities. Critical, right? So that's sort of a classic risk management approach. So we're going to take a look at sort of both of these. First, the legal and regulatory lens, as we look at GDPR and DTSA, and then we'll look at the implications for development. Okay, so first thing with regulatory changes, penalty. Well, GDPR, again, for those of you that may be familiar with GDPR, this is nothing new, but penalties are pretty high. It could be 20 million euros or 4% of your company's gross, whichever is highest, right? So painful, right? So that got everyone's attention. I don't have them bulleted here, but they've also, the EU has made very clear statements that they intend to enforce this. They intend to enforce it to large and small companies. So they've got people's attention. It comes with new organizational obligations, so definition and scope, right? What they've done is they've drawn a clear distinction for inclusion rather than exclusion of these notions of a controller and a processor. Again, I'm not a lawyer, and this is not a tutorial in GDPR, but suffice to say, the controller is the typical owner of the data, right? It's the insurance company, it's the bank. A processor could be the controller, but just as easily, it could be a cloud service provider. It could be a hosting system. It could be a partner in a credit card payment clearing house. So controllers and processors, everyone is invited to be accountable. And it has global reach. If you're an EU citizen and you generate data, whether you're traveling overseas, whether you live overseas, whether the data is created and stored overseas, it doesn't matter. Wherever the data goes, every controller, every processor is on the hook. And interestingly, and I'll show you this in very specific detail, they are using the state-of-the-art compliance standard. What they're saying is they're all about protecting their citizenry, and the fact that your industry historically may be out of date, maybe a laggard, is not an excuse. There is no shelter from the fact that historically you've never been held to this type of a standard before. And so industry norms, as I already indicated, are replaced now by computing best practices. And they have some pretty precise and demanding notification obligations. Again, if you go into the law, there's a lot more words here. But in short, for the most part, if a data breach occurs, you have to notify authorities within 3 days. And you need to be able to identify which individuals may be impacted. And this will come in later when we're looking at the value of certain types of technical controls. A lot of times, notifications go out to a much broader audience than is necessary, simply because the controller, the processor, isn't sure who may or may not be impacted. And so when in doubt, you have to assume they were impacted. That increases cost, it increases complexity, it damages reputation, it will increase probably the number of civil lawsuits you'll be able to expect. So to the extent you can be more precise about who is impacted through evidence that you can really believe in and you can demonstrate is legitimate, that's actually a huge opportunity for savings and risk mitigation. So, I started responding to posts and bulletin boards and things on GDPR a while ago, and what I found was a lot of people were writing based on their impressions from the summary that's come out of GDPR, and it's a very nice summary. I mean, it's not really incorrect, but it omits a lot of things. And if you're impacted by GDPR, you just have to read the whole. You just have to read it. You may not, make sure you have the lawyers there and make sure you're getting good professional advice, obviously. But you have to read it. And the reason you have to read it is because, and we'll see this in the Defend Trade Secrets Act as well, that words are being introduced into the law that lawyers don't often understand. And there are terms that lawyers are very comfortable with that engineers don't appreciate have a special contextual meaning. And until you sit down and read it, you're going to, you leave yourself open. So in this particular case, I just highlighted a couple of examples. Clear indication, security of processing, state of the art, right? Now it's balanced. You should also think about the cost of any control you might consider. You have to think about how likely an incident is to occur. This classic risk management approach, nothing special here, other than they're saying state of the art. And whereas obviously this is about PII, protecting human EU citizens' data, they're calling it out. You have to secure the applications. You can't secure data unless you secure the applications that process that data. And they go into quite a lot of detail. And a good thing to read also, as you're going through this, is to look at all the recitals, all the definitions they include at the bottom, because they really disambiguate everything, right? And so one of the things that I didn't call out yet, but I think is also important, was regulations in general. That engineers often don't appreciate. Risk people, regulators, lawyers, they all get this. But it's not enough to be compliant. It's not enough to do what you're told to do. You have to demonstrate that you've been doing that. And that's another level of work, right? If I train everybody and I explain to every employee in my company what PII is and how they should treat it differently, well, that's my obligation, certainly. But I then have to also be able to prove to an auditor that I trained them and that they understood it and that they acknowledged it, right? So again, risk people, you get this. But the idea is being able to, so any technical control you introduce, you have to also be able to, or you should expect to be required, to be able to demonstrate that you included it, right? So you have to adjust policies and procedures, so on and so forth. One of the key parts around develop, they talk about it in terms of processes, but it's explicit with development. right? You have to have data protection by design and by default. So if you're a development organization building software that is processing PII, you have to be able to demonstrate that in your design, you have the state-of-the-art protective controls and that they are on by default. Right? The other interesting thing, again, they call out applications again. The other interesting thing that I'm not going to spend a ton of time on because it's almost an entire other presentation, is that it impacts the supply chain. Right? So they're not telling you that when your suppliers, if you're subject to GDPR, they're not telling you all of your suppliers must comply with GDPR, but they are suggesting strongly that you take their ability to meet those obligations into consideration. And I cut off the last word in the context of public, I don't know what it is, it's request for quotes. I forget the European term for it, but it's, they're public bids or something. But the idea is they're saying, you should use it. Now, this is an important point. As another anecdote, and I don't go into this in detail in this session, but Anthem, recently took about a $350 million hit because of their data breach. And it wasn't because they did not meet the requirements of HIPAA, right, which is where those fines and civil lawsuits stemmed from, the data breach as it related to HIPAA. The reason they got slammed, even though they met the letter of the law, the HIPAA obligations, there was tons of advice and best practices that were coming into common practice after the HIPAA rules were published. Encrypting data, for example, customer data, was recommended. It was not required. Okay, that's fine. But once everybody else was doing it, that turned into a problem for them, right? And so when you see something like this, that you recommend, the regulation with teeth like this recommends that you include GDPR compliance capability or awareness into your bidding process, you are well advised to do it, or at least to document why it made sense that you did not do it. Okay, so all of that, maybe you think I've beaten that to death, but I'm myself a skeptic, and so I read this. I'm not a lawyer. I actually have tried to get in touch with sort of the senior 2 and 3 people in the EU that are sort of setting this policy. Surprise, I've had trouble getting in touch with them, but they do provide a public way to post inquiries, and so I did. I wrote to the EDCC, and I could share that link with people if you want to fill out your own questions. In summary, I said, would a data processor, be subject to all of these state-of-the-art, obligations to do all these different things under the GDPR if that processor wasn't just processing PII, but if they were writing the code that was processing that PII, would these obligations extend upstream to their development practices? And in particular, would they be subject to punitive damages if they were to include what would otherwise be considered avoidable vulnerabilities that were subsequently exploited, right? So if I'm doing something really dumb, and when I say really dumb, I don't mean industry norm reasonable, but other experts in the digital economy know these are things you shouldn't be doing, and you do it, and that's exploited, are you liable? And happily, they wrote back. And you can read it, but taking the bureaucratic wording away, in short, the answer was, of course, yes. Right? You're supposed to implement appropriate technology and technical and organizational measures. And if you're building software, then appropriate technical measures are required, right? And that includes the by design and by default. So it's not just ops, it's dev, right? So let's take a step back and look for an example of that, right? So if you go to NIST, they provide a very useful portal where they'll categorize all the known vulnerabilities in commercial software. So they don't even try, I mean, somewhere they may, but in this particular portal, they just focus on commercial products where there are known vulnerabilities. And they're nice enough to bucket them, right? So they'll say different types. So there's a vulnerability that allows me to gain unauthorized privilege, or to access information I shouldn't, or to execute code that I shouldn't, right? And you can look at sort of how these buckets have been, well, increasing. So, gain privileges slightly, code execution, right, spiked this year, is currently spiking. So these are this is known, right? Maybe in your industry, people aren't tracking this as closely as they should, but this is well understood, well known, has been published for years. And if you think about, how do I figure out how to execute code in an unauthorized fashion? I mean, there's fuzzing, there's a couple techniques that don't require any tools whatsoever, but a material percentage of these particular buckets have to be found not through trial and error, but by attaching an unauthorized debugger, systems monitor, emulator, doing something to compromise the environment and the access to then to find that vulnerability in order to exploit it. So this is a well-known state-of-the-art, if you will, risk, right? To secure customer data, you clearly have to secure the apps that process that data. The other thing that GDPR expects of you is that you have a state-of-the-art understanding of the mitigating controls for those risks. Right? So if any of you are, and I know some of you are, developers on .NET platforms, you probably know that inside Visual Studio, delivered as part of Visual Studio for now 15 years, going on 15 years, there's a utility that allows you to harden the app against reverse engineering. And in 2017, the current Visual Studio version, it provides you a utility to detect and defend against attaching a debugger. It allows you to detect and defend if your app is discovered to have been tampered with, to detect and defend if it's being used beyond a certain absolute or relative point in time. So again, maybe if you go to a conference around your particular industry and you're not seeing that all of them are putting in controls to prevent the unauthorized attaching to a debugger, either at start or after the app has been launched, that may be true, but it's well understood that's a tool of the trade for a hacker. It's well understood that there are controls that you can use to mitigate those risks. So you have to ask yourself, are you complying with those obligations, right? The advantages of injecting these controls is more than the fact that it allows, in many cases, developers to be completely hands-free, right? They don't have to do any coding. Sometimes they want to do some customization, but it's not required. But more important than sort of a time-saving benefit is that those configurations, the instructions as to what to inject and when, is in a configuration file that is an artifact in your build. And so you can go back, and if somebody were to come to you and say, how do we know that you really had a control to prevent a native debugger from attaching to one of your threads on this particular drop? And you'll be able to show that. You'll be able to demonstrate that, and you'll be able to demonstrate that you didn't have a rogue developer putting in, custom code. Right? Custom checks against runtime environments sometimes get you in trouble. Right? Volkswagen had a special runtime check that changed its emission results. Right? If it detected it was being monitored, for example. So having a third-party COTS product that can do that for you turns out to be quite important, not just in the control itself, but in demonstrating that you're applying the control. So we're going to share a bunch of resources we'll send you some links on this that sort of talks about a processor's journey. So it'll give you a little more context about how to verify all of the motivations, essentially the risks that your organization feels are material to justify some level of investment and control, and to then step you through the definition of the controls, even going through in sort of selecting different vendors, or whether you should implement or develop some of these controls yourself. And sort of make that sort of obviously good governance, risk, and compliance is an iterative, continuous process. So we'll provide those links with some specific, more detailed discussion of GDPR. So please look for that, and we'll also include specifically, it's more generic, but it definitely applies, which is a template that will, once you sort of start to answer these questions, it'll sort of, you plug it into this template, and it'll give you a reasonable sense, at least if you're using our products, the skill set and the time required to actually implement those controls. That's quite important, as well as, I'll get into this later, ability to benchmark yourself. Now I'm going to move on to the Defend Trade Secrets Act. And the Defend Trade Secrets Act actually came out in 2016. So whereas GDPR goes live next year, DTSA really came into force last year. So there's a lot written about it already. But again, let's map it to sort of get a sense of why it's getting the attention that it is, or lack of attention in some circles. So number one, what are the penalties? Well, for the first time, well, first of all, it's a U.S.-specific law. It does not extend beyond U.S. borders, unlike GDPR. However, it was coordinated with the European directive, so it actually is. There's a common or very, very similar obligations in many jurisdictions. But in any case, it allows for the first time injunctive relief. It means the judge can come in and halt somebody who's you believe may be causing you continuing damage if they've stolen your IP or your trade secret in particular. It allows for some fairly significant punitive fines. It can be $5 million, so it's not equal to 20 million, but $5 million or 3 times the damage, whichever is greater. So 3 times the damage could be considerable, and it could, and a judge can actually multiply that by 2 if there's an opinion that the misappropriation, the theft of the trade secret was willful or malicious, right? New organizational obligations include a fairly explicit definition of what a trade secret is, and we'll get into that briefly. But basically, the most important thing about a trade secret is that it has always been a secret, and so you have to maintain secrecy from beginning to end, and we'll get to that in a minute. And then when we get to definition, and the standard, I should say. And this is a great example of where engineers and lawyers can each feel completely comfortable with the term and have an entirely different sort of internal meaning. So reverse engineering is actually a long-standing protected activity in the law. So if I buy a watch on the street, patents notwithstanding, if I buy a watch on the street, I am free to take it apart, reverse engineer it, and anything I learn from it, I'm allowed to immediately apply to any manufacturing or marketing I might want to do. Okay? Engineers sort of believe that, if I give you a binary, if I wanted you to have the source, I would have given you the source. So I don't want you to have the source. But in the law, you took a little excerpt here, in the law, it actually defines what misappropriation is, like what is stealing, and then it'll, blackmail and all sorts of, normal things you'd expect. But then it says, I told you what it is. Let me tell you what it can never be. It cannot include reverse engineering. So that is not theft. So the question is, how do you reconcile that as an engineer and these 2 points? And the answer, quite simply, is you have to show a consistent process and a set of controls where you have worked to prevent reverse engineering, right? Doors are meant to be opened. There's nothing wrong with opening a door. You put a lock on a door so so that people understand that you don't want them to open the door. So you can't say reverse engineering is not allowed, right? Just to be clear, if we're talking about copyright, a license can put all sorts of controls. Again, not a lawyer, but I'm focusing on material that I've validated. In this particular case, I actually met with the chief legal counsel and the Senate Judiciary who actually wrote this law. And I asked him, did he understand the overloading of the term and all this? And he said, absolutely. This is by design. This is not me or someone else trying to read into it, right? So if you want to protect trade secrets that are embedded in your code or embedded in data that flows through your application, if you think your only guard is the fact that they shouldn't reverse engineer, you may be in for a world of hurt, because you go in front of a judge, and the first thing the defense attorney will do is say, you're right, we took it, but it wasn't a secret. And in fact, if you look at the first number of cases that have actually been dismissed in the last year, this is a very, very common reason that they failed this test, right? So it must be a secret from cradle to grave. I guess good news, if you want to call it that, this does take the reasonable precaution, right? So you don't have to have state-of-the-art protection of your executable, but you do need to take reasonable precautions. And it applies both to data and to code, right? So again, just another important example of technical guidance. So, so for this, the developer's journey, we have a similar set of sort of supporting materials. The key here, because it is a reasonable standard, we have some material that will help you. Again, no rocket science here, but just to give a framework of classic risk management concepts, map them to application development and deployment scenarios, help you identify what's material, what it would take to make those material risks acceptably low. Does not mean eliminate those risks. So we have some framework material there for you. And we actually have done some considerable surveying and benchmarking. And we have a database of now roughly 400 development organizations that have sort of talked about what risks they see as material, what controls they invest in, and then we extract some trends. So, and I'm not going to take you through all the material, obviously, here in the next couple of minutes, but it is not surprising to note that different industries prioritize risks differently. So, manufacturing puts a relatively higher weight on intellectual property theft, for example, versus financial services, which focus, again, they care about intellectual property, but not as much as they care about data loss or corruption, right? So we can tease out a lot of these trends that you can apply yourself. Actually, in the interest of time, I'll skip over that one slide, but we also look at controls in this benchmark. So so again, have you taken reasonable steps to protect your intellectual property, your trade secrets? Well, what percentage of your industry hardens their applications against reverse engineering or puts controls in to prevent a debugger from being used in production? So we not only map those by industry, but one interesting trend that showed up quite a bit, I'll just sort of call it out, is if you're a software development organization, what we see is successful, larger software development organizations still have some priorities and controls in place that are specific to software development, like anti-piracy is a risk that pretty universally is a concern. On the other hand, an ISV that targets manufacturing as their target market actually starts to take on risks and a perception of risk and controls like the market they target. So again, that's not surprising. Just as we saw in GDPR in the first example, they're actually recommending don't even license code or do business with companies unless they share the ability to meet the same types of obligations that you're subject to. So you start to see that. So if you're a software developer, obviously you care about your own risks. Pay attention to the shifting risk profiles of your target markets as well. And then there's other metrics as well, like, for example, larger development organizations have a higher standard than smaller ones. And so if you're a large organization, you found yourself having evolved into a larger organization, make sure that you haven't just kept doing things the way small development organizations do it. And because that might have made sense for you in early days, but you may have outgrown it, and then may come back to haunt you later. And again, just as a sort of a summary, as it relates overall to say just hardening applications, as you can see, the majority of companies are hardening their apps against reverse engineering. It's now a minority, but a healthy minority, 35%, have detective controls, defensive controls, and smaller, only a quarter, have reporting controls in place. But again, if you're talking about reasonable, you're probably only seriously on the hook in prevention and detection, some defensive maneuvers. If you're talking about a state-of-the-art standard, you need to be in the green across the board. One last, because I do want to leave a little time, 10 minutes left, just talk for a second about the third leg of this stool, and this was a recommendation. So these are not regulations, but it's telling because these often are the foundation for regulations to come. And one thing I thought was notable, and again, we'll send you links to all of these original source documents. One thing I thought was notable was that they embraced the state-of-the-art standard. Right, so that's number one. So that is catching on. That is not an anomaly in GDPR. Second, they don't just look at sort of processor, controller and processor. In other words, digital processing of data. They look at the entire supply. Not surprisingly, perhaps, given the industry, but they're extending these standards all the way down the supply chain for parts, aftermarket parts, those types of things as well. And so the obligations have sort of been adapted and extended. We can step through that. We have a document that we will share where we've actually gone through and called out each of the little subsections and sort of just highlight examples of where we're seeing these sorts of trends that will impact the software that runs inside these parts and equipment, as well as coordinate the manufacturing, distribution, and monitoring of that equipment. And the other nice thing I like about this particular document is that they're pretty thorough in citing their sources. So, happily, they're not trying to reinvent the wheel here. Like notions of, prevention, detection, respond, report. A lot of these sort of broad, well understood principles show up in industry standards, and they're very clear on where they're deriving these standards from. So that's extremely helpful in adding additional color and interpretation, and gives you some level of confidence that they're not going to come up with some, business-breaking obligation that will be impossible to meet. The cure cannot be worse than the disease, right? So you want to focus on, does the control hit all of the affirmative characteristics of a control, but you have to also measure the risk, the cost, and the effort of applying that control. And I'll say that at PreEmptive, we spend at least as much time and money and resources mitigating the cost, the complexity, and side effects of applying our controls as we do upgrading the controls themselves. They're equally as important. That's just sort of a summary, so I'm going to just move on. And just sort of closing the loop on sort of how our, sort of the ubiquity of hardening of apps, right? So I already referenced how Obfuscator is a part of Visual Studio, the free version, but that's not unique, right? Java and Android, and obviously, and the sister managed platform, also comes with a free, if you will, community edition of an Obfuscator as well. And there's an open source project for iOS obfuscation. And so regardless of the platform, or almost regardless of virtually any platform you're using, the platform providers themselves, or the development communities themselves, in the case of iOS, are providing these controls. So there is no chance that you could say, we didn't know, or this wasn't common, right? So if you're not going to harden your software, that might be the right decision. This is a subjective call. Risk management in general is a subjective exercise, but it can't be no policy. Write down why you're not doing it and why that made sense. Right? You have to demonstrate that you were effective. Obviously, we provide commercial products for those that need vendor viability and support and updates and timely responses across that spectrum. And I didn't demonstrate it here, but we have plenty of sample code and actually some articles coming out very shortly with more examples of this. Sure, we can emit alerts and raw data, but we can show how to plug in these alerts into whatever dashboard or console that you're currently using, whether it be in IT ops or DevOps or usage analytics, and we can show you how to do that as well. Right? You don't want to reinvent the wheel. You want us to plug into whatever cloud or monitoring or centralized controls you have in place. Thank you all for your valuable time. I know it is indeed valuable. And look for that additional content. If you have any additional questions for me, you see my email, I hope, at the bottom, Sebastian@preemptive.com. You can follow me on Twitter. Follow PreEmptive on Twitter. I don't have that on here, but it's @PreEmptive. Thank you very much. Have a terrific day.